This case relates to the buying and selling of large quantities of pig iron as a commodity. The plaintiffs were a trading firm, and the defendants were suppliers of iron. The way it worked was that the plaintiffs would find out what price they would have to pay the defendants for iron. Then the plaintiffs would find buyers who needed iron. If they could sell the iron for a higher price than they paid for it, well, then they made money by pocketing the difference. On this occasion, the defendant, McLean, offered to sell them iron for 40 shillings per tonne, and he offered to hold the price open until the end of Monday. At 9:42 a.m. on the Monday, the plaintiffs sent him a telegram which said, "Please wire whether you would accept 40 for delivery over 2 months, or if not, longest limit you would give." At the same time, though, there were apparently other people interested in the same iron. McLean formed the view that the telegram was a counteroffer, and that as a result his initial offer had been rejected, because we know that a counteroffer extinguishes a previous offer. He therefore sold the iron to someone else. In the meanwhile, Stevenson, Jacques and Co., the brokers, had found a buyer who was willing to pay 41 shillings and sixpence per tonne. They had made a contract to supply that iron, and so they sent a telegram back still on the Monday saying they would accept the price of 40 shillings per tonne. McLean, though, had already sold the iron. Stevenson, Jacques and Co. therefore had a contract requiring them to supply iron that they could no longer get from McLean. They had to buy the iron elsewhere at a premium, and they sued to make good their loss. The question for the court then was whether the telegram was a counteroffer. The court found that it was not. Justice Lush said, "There is nothing specific by way of offer or rejection, but a mere inquiry which should have been answered and not treated as a rejection of the offer." As a result, there was no counteroffer, and the original offer still stood. It had been accepted by a second telegram, and so the supplier of iron, McLean, was liable to make good the loss. He should not have sold while the first offer was still open.